Good evening, ladies and gentlemen. I will now open this public hearing of the Stratford Zoning Board of Appeals at 7 o'clock. At this time, I'd like to ask all in the council chambers to turn off or at least set to vibrate your cell phones and any electronic devices that you may have so as not to interrupt the proceedings. Today's date is March 1st, 2022. The public hearing of the Stratford Zoning Board of Appeals will come to order to hear those petitions that were advertised for this session. For those of you that are not familiar with our process, each petitioner or their designated representative will present their case to the board. When they have concluded, board members will then have an opportunity to ask any questions they may have. I will then ask if there is anyone who wishes to speak in favor or in opposition to any petition. We shall ask that all petitioners to speak clearly and directly into the microphone. After all petitions have been heard, we will then recess to our administrative session. Interested parties are welcome to stay. However, only board members and staff will be allowed to speak at this time. We asked that there is no clapping or demonstration or shouting as a way of expressing opinions because it will have no effect on the decision of the commission. At this point in time, I would ask Mr. Llewellyn to please read into the record petition number 1.
And number 2, if you would, Mr. Llewellyn.
That's very good, thank you. We'll take 1 and 2 at the same time since they're the same parcel.
Excellent, so I'll just go right from one into the other. So our first item is 600 Silver Lane Church, which is the petition of 600 Silver Lane LLC seeking a site plan review and variances of section 4.2 of the side yard setback for a proposed free cut upon the lot to separate the church from the existing house. And our second item, number 2, again, 600 Silver Lane, this labeled as the house. This is the petition of 600 Silver Lane LLC seeking a site plan and review and variances of section 4.2 of the side yard setback for a proposed free cut upon the lot to separate the house from the existing church.
Good evening, Lady Commissioners, Madam Secretary, Mr. Chairman, Commissioners, and Mr. Brendan. My name is Barry Knott. I'm a lawyer with the firm of Knott, & Dunn with offices at 1656 Main Street, Stratford. I'm here this evening on behalf of 600 Silver Lane LLC, Post Office Box 524, Stratford, which is the owner of this property. At this time, I'd like to submit the certificates of mailing and also photographs of the front of the 2 buildings reflecting the fact that we posted the signs on this property as required by state statute and local regulations. Now, I want to reference a folder of exhibits which I have just handed to each of you, to which I'll be making reference during the course of my presentation. The first 5 of which are photographs of the property, which are the subject of this application. And as you can see, photograph number 1 is a picture of the 2 buildings that are located on this approximate 2-acre site. It's a church and a rectory, essentially. That's what's there now, a church and a rectory. And photograph 2 is another photograph of the same property taken from a different perspective on Hawley Lane. Now, the one thing I'd like to point out to you in photograph number 2, you can see on the side of the church, as you face the church, on the right side of the church, there is a ramp coming off the right side of the church. That ramp will need to be removed as a condition of this approval because we don't have enough room to maintain the ramp. And this building is not going to be used as a church going forward anyway. So the ramp is coming out. You can see it there. Photograph 3, another perspective. Once again, you can see the ramp on the side of the church to be removed. Photograph number 4 is a picture of the house and the property to the west of the house, which is essentially a large wooded area. As I indicated, this property sits on approximately 2 acres of land. And number 5 is a photograph of, another photograph of the wooded area on this property. Now, Exhibit 6 is a site plan which, a larger version of which you have in your file, but I've taken this one, and what I've done is I've outlined in red a approximate 10,000 square foot lot upon which the house sits, And I've outlined in blue an approximate 87,000 square foot lot upon which the former church sits. And the plan here is to create a lot that conforms to the zoning regulations, which is known as Lot 2 on this site plan. That's the lot upon which the house sits, in order that my client can sell the house parcel from the main parcel, thereby creating two parcels as opposed to one. Now, in order to do that, we need a variance for both buildings from 12 feet to 10.1 feet, side yard variance. This is an RS3 zone. In an RS3 zone, the side yard setback is 12 feet. There is exactly 20.2 feet between the side of the house and the side of the church. Once the ramp is removed, 20.2 feet. We need 24 in order to have 12 feet from each house. So we're short 1.9 feet as to each building. So therefore, we're asking for a variance from 12 feet to 10.1 feet, respectively. This lot, as I indicated, is in an RS3 zone. It requires 10,000 square feet of lot area, each lot, 100 feet of lot width, and 100 feet of lot depth. And if you look at the dimensions of Lot 2, which is the house lot outlined in red, we conform in all respects to the minimum lot size, front yard, lot width, and rear yard depth with respect to that parcel. So, should these variances be granted, it's the intention of my client to sell off the house that would otherwise be a conforming lot except for the side yard setback. In other words, the house lot, known as Lot 2, contains 10,490 square feet, more than 100 feet of lot width and more than 100 feet of lot depth. Separating the house from the church and the lot upon which it sits, which is known as Lot 1, the church lot is known as Lot 1, would leave the church on a lot containing 86,700 square feet or 1.99 acres. This lot would also conform to the minimum lot requirements in an RS3 district, except for the side yard setback issue. I want to give you the history of this property. Exhibit 7 is a copy of records from the Planning and Zoning Office, which shows a special case approval granted for this property in February of 1967. As you can see from this exhibit, special case approval was granted to St. John the Baptist American Carpathian Russian Orthodox Greek Catholic Canonical Church of Stratford, and there's a mouthful, in 1967. This approval was necessary because churches are required under our zoning regulations. They're permitted in a single-family zone under our zoning regulations with special case approval. So because this is a residential zone, because they were seeking a church, they needed special case approval when they bought the property in 67, and they got special case approval in 1967. Purpose was to construct a church and a rectory on this property. I mean, at that time, it was never intended by the applicant that the house would be sold as a separate parcel from the church. It was always going to be a church and a rectory, okay? Having said that, I believe that in order to comply with the side yard setback requirement in 1967 for RS3 zone property, that the house and the church should have been constructed 24 feet apart. They should have been constructed 24 feet apart. They weren't. They were constructed 20.2 feet apart. Now, I've been doing this a long time, 47 years, and things are done a lot differently now than they were back in those days. Builder would go out, yeah, that looks about right. We'll put the house here. We'll put the building here. No as-built, no specific dimensions were used. I mean, I've seen houses that were actually built on the wrong lot. I've seen houses that were built with half of the house hanging over onto the lot next door in Stratford. Not now, but back in the day. So here, whoever built this church was shy the difference between 24 feet and 20.2 feet. In any event, these applications for variance request the variances of essentially a de minimis nature, de minimis, 12 feet to 10.1 feet. The buildings themselves will remain exactly as they are now, with the exception that the ramp on the side of the church will have to be removed in order to make the requested setback distance of 10.1 feet. No new construction is anticipated as a result of these applications except for renovation of the church, which is going to be turned into a single-family house. The house that's on Lot 2 will simply be sold off on a conforming lot, leaving the church to remain also on a conforming lot. There will be no disruption to the neighborhood as a result of any new construction on this property. Procedurally, however, additional steps will be necessary for us in order to separate the house from the church if these variances are granted. First, we have to apply to the Zoning Commission for a modification of the special case approval that was granted in 1967. We're changing it, so therefore, and it's not going to be a church anymore. So we have to go back to the Zoning Commission and say, hey, we need to modify the special case approval that you granted in 1967. Secondly, because we're cutting off a lot from a bigger piece, we have to go to the Planning Commission for subdivision approval. So this will be the first step of a three-step process: BZA, Zoning Commission regarding the special case, Planning Commission regarding setback. However, none of these applications can be submitted until these variances are granted by you. Now, Dan Brennan submitted some administrative comments. First, he points out that the proposed approvals could be construed as being consistent with current neighborhood character. For reference, the average lot area for houses on Silver Lane is approximately 10,000 square feet, which is what these lots will be, one of the smaller of the two. Secondly, he points out that the property is one non-conforming lot with two principal buildings on one lot, and the approval of these variances will be creating two non-conforming properties in regard to side yard setback. Now, what he means by that is Section 1.1 of our zoning regulations does not allow more than one principal building on a lot. Here you got one lot and there's two buildings on it, a church and a house. That's a non-conforming use because it violates Section 1.1. So what's happening here is we're asking you to eliminate one non-conforming use, which is two houses on one lot, and allow us to have two non-conforming uses, a variance from 12 feet to 10.1. Now, in my opinion, having two houses on a lot is a far more serious nonconformity than having a side yard setback from 12 feet to 10.1 feet. Nobody's going to notice the side yard setback variance from 12 feet to 10.1 feet. No one will ever know. Who goes out and measures the distance between houses? So this is a far more benign request than that which exists now, which is the nonconformity of having two lots on, two houses on one lot. Now, in his comments, Dan suggests that the hardship is self-created and of a financial nature. Now, I disagree with that conclusion. First of all, the need for the variance was created when the church and the rectory were built in 1967. Fast forward 55 years. It's been 55 years from 1967 to now. The church is now vacant. The property is sold to a new buyer who is simply trying to do the right thing by this property, by being able to sell off this house. This request represents a legitimate hardship, and the need for the variances was created 55 years ago by someone other than the applicant. My client did not create this hardship. It's not self-created by my client. In fact, the granting of these variances will result in a less significant nonconformity than currently exists. If anyone was responsible for the hardship, it was the representative of the church who constructed the building 2 feet too close together in 1967. If it were anyone who created the hardship, we could say it was God that created the hardship when she directed her agents on earth to construct these facilities where they were ultimately located. So I don't like to point fingers at God. However, the hardship here was created by an agent of the Lord deciding to build these two buildings 2 feet too close together. So it certainly isn't a self-created hardship. And I'm being somewhat facetious by saying that, but no one is responsible for this. And this is the right thing to do in order to straighten out this property. Thank you for your consideration.
Thank you, Mr. Nutt. Questions from the commission? Ms. Gibson?
Yes, I do have some questions. What would the setback, like that side of the house, you know there's a plan to develop and make 2 homes there? You know they're going to do...
I'm having difficulty.
Oh, I could take this off. All right. Oh, thank you. All right. Yeah, no, I was, my question is, the part where the hardship is, what is that area going to be when they rebuild?
Lawn.
It's just going to be lawn? Oh, okay, not a driveway or something like that?
A side lawn.
Just a side yard?
each
Okay.
structure.
Okay.
Where the ramp is now on the church, the ramp will come out and that'll be
And it'd
lawn.
just be lawn?
And then same thing with the house.
And you said it was a subdivision, are they going to continue to have that?
No, the only subdivision I'm talking about is to create 2 lots where there is one now.
Okay, just
We
the 2?
need to go for subdivision approval in order to do that.
Okay, all right, thank you.
Thank you. Any other questions? Ms. Witham?
So the new owner, were they aware of this non-conforming situation of this lot? I mean, if their intent was to sell off a piece of the lot.
I don't think they were, because when they bought this property in October rather, of 2021, they did not have it surveyed until January of 2022. So they found out 2 months, 3 months after they bought the property that they were short this 2 feet, 3
So they
feet.
kind of didn't do their homework? Because to me, I didn't think anything financial, which is obviously they bought it with the intent to sell the house. I didn't think a financial situation is justification for a hardship.
Well, hardships are determined by the individual facts of each case, and there is a line of cases that say if you have a nonconforming use and you create a less intense nonconforming use, you don't need to prove a hardship. So in this situation, it's my position that we have a nonconforming use now, 2 buildings on 1 lot. That's a fairly egregious nonconforming use. And we're going from that to 2 nonconforming uses, which is essentially a 1.9-foot setback on each side yard. So from the neighbor's perspective, they're not even going to notice the side yard setback from 12 feet to 10.1 feet. So I think that's a much more benign nonconformity than having 2 buildings on 1 lot.
Thank you.
Any other commissioners with questions? Mr. Nutt, so now I'm intrigued. So I see what you're going to do with lot number 2. Carve out the house. You're indicating they're going to build, the intention is to build a house on lot number 1?
Not build one, build the church into a house.
Convert the church into a house?
Now, obviously, the steeple's going to come off. You know, that's not staying.
So the new lot will basically wrap around lot 2 on all sides except for the street?
That's correct. Now, remember, this is an RS3 zone, so individual lots only have to be 10,000 square feet. Is it possible that the balance of that property will be subdivided in the future? I would think so. You know, I would think that they would be. However, if we're talking about 10,000 square foot lots, they're all going to be conforming lots. All the lots on the street are 10,000 square feet. I don't know what the future plans are.
Okay, thank you. Ms. Gibson?
If in the future they sold the house, would this setback be a problem in between every other house? Are we setting the tone that they would be able to be less 2 feet in each?
No.
Okay.
No, that's a good question. Let me explain that, because that question comes up oftentimes at these board meetings. The commissioners say, well, if we grant this variance, are we setting a precedent that's going to bind us in the future? The answer is no. Legally, under Connecticut cases, Supreme Court and Appellate Court, each individual land use application, of which this is one, is treated on its own merit, on a case-by-case basis. So if you were to do this today, and the guy that came in next month and asked you to do it, you would not be bound by having granted this variance tonight.
Ms. Witham?
So why wouldn't you make the lots more even? Why is it wrapping around? I know there's also a text amendment proposal trying to get through one of the commissions.
Well, that has nothing to do with this property.
I didn't say it does now, but leaving this bigger than the acre, you know, and supposing, and if that text amendment goes through, that leaves this available also for the multifamily housing. I know it only goes to Emerald now, but, you know.
It only goes on Broadbridge Avenue.
So,
The text amendment, and I'm aware of what you're talking about because I'm
I know.
representing, but that text amendment only applies to properties on Broadbridge Avenue 200 feet back from the street. This property is nowhere near.
no, I know, but for now is what, I mean, that's what the proposal is for now on the Broadbridge Avenue
Yeah,
side. But
that's right.
that could be
Well,
opening up for more.
I don't agree with that. I mean, you see what I'm going through just to get this thing approved. I don't see the zoning commission expanding that regulation, even if that one gets passed. I don't see them expanding it into other areas of town. It certainly isn't going to be near this.
So then why would you wrap this around this house? Why wouldn't you split
Because-
it
because
differently? Because there's
wi-
obviously another plan, it
Well,
seems.
if you look to
in the
the right,
future.
if you look to the right of the house,
Mm-hmm.
as you face the house, there is an area there that we could get probably 1 or 2 more houses if it were to be subdivided. It looks close to being able to get 1 or 2. Or it's conceivable that a road could go in and you could get 1 or 2 houses in the back. So the idea is to create a lot that complies with the minimum lot requirements in this zone, which in this case is 10,000 square feet. And then as to the rest of the property, they'll deal with that later. But it wouldn't be prudent for them to.
But is the hardship, I mean, the hardship seems like it's more financial in order to sell it first before you start talking about the setbacks.
The hardship wasn't created by us, but by
It
my
doesn't,
client.
does it matter who it was created by? I mean, like I said, the person who bought this knew, or should have known, if they didn't know, they should have known what they were buying. You can't deny that.
Well, they wouldn't have known it by looking at it because they wouldn't have been able to see the distance.
But if you're buying this big of a piece of property with the intention of at least doing this and then probably doing more, I would think that you would have it surveyed
Well, they
to know
did,
what you
except
have.
not until January of 2022, which is the date on that
No, I
plan you've got
understand
in
that.
front of you.
But I'm just saying that seems like they didn't do their homework, and now they're coming to us to approve something that I'm not sure
One
makes
thing
sense.
I don't know if this is the first time I've appeared before the new BZA or not, but the Board of Zoning Appeals, the purpose of boards of zoning appeals is to grant relief from the zoning regulations. That's the purpose of the Board of Zoning Appeals, to grant relief, not to enforce the zoning regulations, to grant relief. And oftentimes people don't remember that. And I just want to say that so that I will have said it, because it's very important. And in a situation like this, we're talking about nothing as far as the variances are concerned. Who's going to be hurt by this? Nobody.
I think as far as the feet in between is not so much the issue, is more just like Dan said in his staff report, it seems a little bit self-inflicted. They didn't do their homework, as far as the lot, as far as the lot as one big piece now,
So does that mean that you deny a variance of such a de minimis nature just because somebody may have been foolish enough to buy a piece of property without having it surveyed? That's not reasonable.
But that's where the that's where the hardship is coming in. It's financial because he can't sell it until that happens, is what I'm trying to say to you.
If this variance is denied, we're never going to be able to sell that house without knocking down either the house or the church. That's not a reasonable result. It's not reasonable. Especially if I was asking you for a 15 or 20-foot variance, that's one thing. But we're talking about 1.9 feet here.
I understand, Barry, but I think, again, they should have done their homework, whoever your buyer is.
Well, I take them as I get them, you know what I mean?
I get that.
What can I tell you?
Thank you.
So now let me ask you another question here. So this piece of property originally got a special case in 1967, correct?
February.
And in that special case, the zoning at the time required 12 feet between structures, correct?
That's true.
Town of Stratford issued the special case permission, and the building department issued a
Building permit.
building permit
Right,
with plot plans.
correct.
So the town of Stratford knew that this proposed development did not meet the requirements of the zone.
That's correct.
So if your prospective purchaser comes in here, sees these two structures, it is reasonable to assume that the town of Stratford would not, in their ultimate wisdom, have signed off at the building department creating a non-conforming lot or a non-conforming situation. First off, they put two buildings on the same lot, but notwithstanding, they put them too close.
Right.
The town of Stratford should have known, guys, here's the plot plans, this is the zone, you can't issue a building permit based upon what was applied. So I'm saying that your client had every reasonable thought process, the purchaser had every reasonable thought to say, the town of Stratford wouldn't have let something go like that, so it must be within compliance.
That's true, Gavin, and I agree with you. However, I just want everybody to be aware that neither the building department nor the planning and zoning office in 1967 examined the specific details of site plans the way they are examined today. It was completely different
It was
story.
a completely different world back
Yes,
then.
it was. Yes, it was.
I was very young, but I do recall. Thank you. Any other questions from the commissioners? Thank you very much. Is there anyone here who wishes to speak in opposition to the petition? Opposition? All right.
Couple minutes.
Yeah, we need your name and address for the record. And if you could-
Suzanne Swain, 20 Masna Place.
Yeah.
My property butts up the church. and
Okay,
the-
if you feel comfortable, could you take your mask off? It just makes it a little easier, just lower it. It just
No
makes it a
problem.
little easier for us to understand. Thank you very
Sure.
much.
Suzanne Swain, good evening. 20 Masna Place. That's the property that is on the right-hand side of that house, which they're calling Parcel 2. 20 Masna Place. That would be the back portion of my property. My question is, because I don't have any kind of paperwork or specs on what their intention is to do with that property that they're talking about, how far back that other property will be wrapping around, because it does affect at least 3 houses on that particular adjacent street, as far as back property.
Mr. Knight, would you care to share with this individual plan?
Here's the church, here's the lot. And we're just taking the house on a 10,000 square foot lot and separating it from the rest of the property. So it's not going anywhere near your property or any of the other properties on
Well,
Mass.
that's my property.
No, it's not. This is the church property. Your property's over here.
Oh, so this property would be a part of Parcel 1.
That's right.
So this property would be a part of Parcel 1. 20 Masna Place. 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 which the intention could be that when it's come in, they will initially put in multifamilies there.
It's a single-family residential zone, single-family residential.
So one property will be on parcel 1 and one property for parcel 2.
The church remains on parcel 1, which is the big piece, and the house remains on the smaller piece.
Okay,
And this remains as one piece.
my question that I'm concerned about is, I know that it says that now, but you did say that there's a possibility they could resell that property, and the other person that comes in decides, okay, we're going to put in divisions or whatever they want, and then clear that property in the back. So my question was, as if I'm sorry, Mrs. Whittam mentioned, why not split the property a little bit more evenly so this parcel 2 is more evenly split? So it makes more sense for single family to go on both properties rather than leaving the door open for it to turn it into something like multi-use for future. Because anything can be said today, but it can definitely in real estate change in 3 years. That affects not just myself, but the adjacent properties. And unfortunately, I don't see any of my other neighbors except for my neighbor right there that's across the street. But that's my concern, because right now it's a wooded area on the property where the church is, out to the right side of that church is wooded. Right. Beautiful. But it won't be so beautiful once it's cleared to make multi-use.
There's no intention of doing anything other than selling this house.
I understand, but that's where my question lies, is why not, I don't know if everybody has this spec, right? Is this going to be mine? You can have that. Okay, thank you. Why not make the properties, if you're concerned about resale on the property, I don't know what that single property square footage would be, acreage. What would it be sold as? What's the acreage on it? Do you have an answer for that, sir? What would the acreage on this property be?
That is a quarter-acre lot, and the reason why we're doing it this way is because that is the minimum size lot that is required in this zone. So that is the reason why it's being done this way.
I see.
We are required to create a lot at least this big.
And my question, do you know what the size of this lot, this part of the
2
lot
acres.
would be?
This whole
Not
thing
this
is
whole
2.
one, just this area here.
No, I don't.
Okay. That's my concern. You see, because I'm the budded neighbor there. And my wall only goes but so high. I don't necessarily want to be looking into the back of someone else's, the view of the property can change. And unless there is a guideline here that says, we're not going to chop down all those trees. But I can't see the money in it to just say, yes, let's sell that as one property, a wraparound of someone else's house. For future, that doesn't seem financially feasible. Do you know what I mean?
Understand.
So that's my voiced opinion. I would like a clearer stance of what that property would entail just to make it this way. You know what I mean?
Correct. I understand.
It would make better sense, and if it's not that big a deal, why not do it? Then whoever takes that house has room to be a single family, and it keeps the neighborhood as a neighborhood, rather than townhouses, potential townhouses, which is my concern, okay?
Thank you.
Thank you.
Anyone else to speak in opposition? Name and address for the record, please.
Hi, my name is Lisa Cadrin, C-A-D-R-I-N. I'm at 610 Silver Lane. And I have a question, because I bought my house in 2007, and I have a parcel of land in the back of my home, and I was clearly told that it is non-building land back there. You can build nothing. So I'm just curious why, just a couple houses down, they're able to take all of these lots and start building on them. Because I was told that's all non-buildable land there, so I'm just curious as to, you know, how this project could even move forward.
Well, actually, there is, just for clarification, and I'll let Mr. Knott speak for it, but there is no proposal to build anything on the lot that's not there now, other than knock the church down and put in, as Mr. Knott indicated, a single-family home where the church is. There is a single-family home there now, and what they're asking us to do is basically carve out and create a lot. They have not come before us or any other land use commission with any other plan to do anything else.
And I understand that, but I've heard a couple things that they don't know what they're gonna do with the land. They wanna sell off the one house, but then you have all this other parcel of land and the church, which they say now they're converting into a home,
Correct.
so. I don't.
But the only thing that's before this zoning board of appeals right now is whether or not to grant that single lot, to carve it out and grant the variance to allow a setback, not even to create the lot, just to allow the setback. They would have to go before the, as Mr. Knott indicated, they have to go before the zoning commission, and they have to go before the planning commission. So this is just the first step in the process. But what we are what our responsibility is to determine whether or not the variance, which is a setback from 12 feet to 10.1 feet, is legitimate. Thank you. Ma'am?
Alicia Huggins. I'm at 15 Masson Place.
Alicia
I'm
Huggins.
across the street from some people that are about the property that we're talking about.
Yes.
I just want to say that I hope that you will consider what my neighbor has suggested to divide the land a little bit more evenly. And also keep in mind that should in the future there should try to put a street in or something like that, there's already a driveway which is fine. But off to the left there, you have the high wires from the electric company, and you have, you may have wetlands there. It needs to be looked at to see if they've been designated as wetlands, which might be why other people can't build on open spaces that are there.
That's right. Thank you. Anyone else in opposition? Anyone in favor of the petition? Anyone in favor? Hearing none, the chair will entertain a motion to close petitions 1 and 2.
So moved, Mr. Chairman.
Moved by Mr. Llewellyn, second by Ms. Witham. All those in favor, say aye.
Aye.
Opposed? Motion carries unanimously. That ends the public hearing portion, so I'll take a motion to close the public hearing and go into administrative session. By Mr. Llewellyn, second by Ms. Witham. All those in favor?
Aye.
Opposed? Motion carries. We will now go into the administrative session portion. First item on the agenda is items listed in the public hearing agenda dated March 1st, 2022. The chair will entertain any motions, take any petitions off the table.
Yes, Mr. Chairman, for the purpose of discussion, I would move that we take items 1 and 2 as discussed in the public hearing session.
Okay, we have a motion to take it off the table for 1 and 2 for discussion, second by Mr. Tiki. All those in favor?
Aye.
Motion passes unanimously. The floor is now open. Anybody wish to speak on petitions 1 and 2? Ms. Gibson.
I would just like to just point out that I understand the concerns of residents in the community. And I myself, when we vote, will be considering, you know, that it is a small amount in between for the lawn, but I'm hoping that we're not setting a precedence to go forward. But I do understand what the attorney said about, you know, what our respect to do for the zoning board when it's time to present it there. So that's all I would like to say for now. Thank you. I think we should put it on the table. I mean.
There's a motion put on the table by Ms. Gibson. Is there a second? Chair will second it. All those in favor of putting it on the table signify by saying aye.
Aye.
All those opposed to putting it on the table signify by saying nay. Hearing all those, any abstentions for any reason? Hearing none, the petitions are put on the table by 5-0 vote. Just for the record, there will be no Sorry, I didn't realize my mic was off. I apologize. There will be no action taken on this petition this evening. It is tabled. Our next administrative session is the first Tuesday of April. I don't have my calendar in front of me. I think that's the 6th, 5th? Oh, I have it right here. Just so that everybody's aware of what the next date would be, it will be... That is correct. It will be Tuesday, April 5th. It will be here. There may or may not be a public hearing prior, not on this issue, but depends if we have any other petitions. So check the website and keep yourself appraised as to whether or not there will just be an administrative session or not. Okay? Thank you very much for coming out. Thank you, Mr. Knott.
Thank you.
Next item on the agenda is the approval of minutes of February 1st. Chair will entertain a motion.
Motion to approve the minutes, Mr. Chairman.
Motion by Mr. Luan. Do I hear a second?
I'll second.
Ms. Witham, any discussion on the motion? Hearing none, all those in favor say aye.
Aye.
Opposed? Motion carries unanimously. Campsite plan review, there is none. Erosion control, there is none. Members' concerns or comments? Seeing none, any other items that need to be discussed? None? Chair will entertain a motion to adjourn.
I'll second.
We have to have the motion first.
Oh,
Ms.
okay.
Witham, you'll
Oh,
make the motion.
yeah.
Ms. Gibson, you will second.
Sorry.
All those in favor of the motion to adjourn say aye.
Aye.
Motion carries unanimously. We are off the record. Thank you very much, ladies and gentlemen. Thank you.